Welcome. Today, we explore two landmark U.S. Supreme Court decisions that forever changed how we balance freedom of speech and protection from defamation. This is the story of New York Times Co. and Sullivan, and Gertz and Welch, and their impact on strategic communication. The press holds power, but so does a name. A single sentence, printed, posted, or spoken, can build a reputation or bury it. In the digital age, defamation isn't just a legal issue. It's a weapon, one that can destroy trust, credibility, and careers. Let's analyze the two rulings that define the line between reckless speech and protected speech. Two cases, two contexts, one foundational legal framework. First, we revisit New York Times versus Sullivan, decided in 1964, the case that gave birth to the actual malice standard. The New York Times ran a civil rights ad in 1960. It criticized Southern police brutality, but didn't name L.B. Sullivan, a Montgomery commissioner. He sued for libel and won under Alabama law, even though he wasn't named. The Supreme Court reversed the ruling and history. To protect public disclosure, the court raised the bar. Public officials must now prove actual malice, that a statement was knowingly false or published in reckless disregard for the truth. This decision gave the press breathing room and placed burden of proof on powerful officials. For communicators, this ruling reminds us accuracy matters, especially when our words shape how the public views authority, justice, or identity. Elmer Gertz was a private lawyer, but an ultra-conservative magazine falsely accused him of being a communist and a Leninist. This time, the court ruled in favor of the individual. Gertz didn't seek the spotlight. He was defamed and dragged into public controversy without cause. The court ruled that private individuals deserve more protection. They only need to prove negligence, not actual malice. Here's the key distinction. Public officials and celebrities must prove actual malice. Private citizens only need to prove the speaker was negligent. This legal boundary still governs journalism, public relations, and political speech today. False claims don't just hurt people. They erode trust in the system, in journalism, in law, and in civic participation. Reputation is more than an image. It's access, livelihood, and dignity. Gertz never sought public fame, yet he was treated as a target. The ruling clarified that simply being involved in a public issue doesn't make you a public figure. The lesson: verify before you publish. Fact check. Seek comment. Avoid reckless assumptions, especially when the damage could be permanent. Together, these two cases set the boundaries for more modern defamation law. They protect the public from being silenced and protect individuals from being destroyed. As communicators, we're not just content creators. We're strategic actors. Knowing the law isn't optional. It's how we avoid lawsuits, maintain integrity, and elevate the truth. All legal citations and research materials are sourced from the Legal Information Institute at Cornell Law, U.S. Supreme Court rulings, and academic resources on First Amendment law. Thank you for watching. May your words always reflect your truth, and your truth always reflect your responsibility.